would be without this child. Don't think he wouldn't give a 14-month-old baby to his father. And this was to a man who was a complete stranger both to my child and to me. And because of that, like many other mothers who faced abuse and faced having their children taken, I fled for 2 weeks. But I came back on my own accord, and since that time, 2 years ago, I've had little to no contact with my child. On the subject of mediated settlement agreements, an abused and psychologically, emotional, or physically abused person is more likely to sign something that they do not agree to because of fear. Additionally, 54% of abusers, convicted abusers, these are not women who didn't report something because they were too afraid. Convicted abusers receive primary custody of their children. Abusive people can also use the court system to limit contact with their child through extortion and financial means. They can stir up contention and prevent someone from coming to court, especially if they do not have proper representation. Now, I think that mediation should occur, but I'm also learning that people can be coerced into signing an agreement by fear and by attorneys who have a vested interest in either throwing the case or a specific outcome. And this can be highly influenced by other people involved in the court system, professional supervisors, guardian ad litem, people that are not accurately representing and reporting what's happening. And so mothers are told, play the game, do what you're told, and keep your mouth shut. And sign this, or you will lose your child permanently. So I think there's some real problems with the mediated settlement agreements. If a mediated settlement agreement, the way the law is written right now, there's something stated on the top where it says it's irrevocable, or if it's subject to arbitration, it's irrevocable, that it cannot be fully explained. If a mediated settlement agreement ends up removing rights and access of a parent, then a judge must have the authority in these agreements to throw out the agreement that effectively removes a good parent who has done nothing wrong and who is a citizen and productive and has, contributes to society in a very effective way. A judge needs to have the right to look at this and say, does this agreement follow the law? Does it keep both parents in the child's life? Why are these people in litigation? Is there any really evidence shown to the court? Why would someone sign an agreement and then spend months and hundreds of thousands of dollars coming back to court saying, Judge, I screwed up, I signed this, I didn't understand what it meant, I wasn't given good legal advice, and now my 1-year-old, my 2-year-old, my 3-year-old, my 9-year-old, I don't have access to because of a mediated settlement agreement that's irrevocable. Arbitration and mediation should not be binding and irrevocable. Personally, because of a mediated settlement agreement, I have lost all contact with my child. Why? Because my liberty and access to my child was threatened for missing 5 visits with the father, which I mentioned previously, of my nursing infant baby who had nothing to do with his father before I filed for child support. Now, if you force people into doing mediation too soon, or even later on, I think you should maybe do a mediation initially, but people can be afraid, especially in family violence situations, or if you're facing someone who is seeking complete power and control of the family dynamic, then you can end up with something where someone can be removed from their child's life, especially the way the system is now because of the corruption that's happening in the family courts. Emotional and psychological abuse is real, and the EU, they've just passed a law where now it can be prosecuted in terms of the power and control dynamic that sometimes exists without object physical evidence, and also can be used, that sort of evidence usually exists in terms of like written word or spoken word or observations of the repeater, where stuff like rape and actual physical violence that's harmful usually is hidden and covered up, or can end up not being reported. So with these sort of situations, even with an attorney, someone can sign something that they should never actually sign. And judges right now currently don't have the oversight to oversee this. Mediation also, if it does occur, in addition to these institutional oversights, it should occur before, years and years of litigation. In my case, I went 2 years of litigation before finally a mediated settlement agreement. During this time, I lost one of my homes, I lost a car, I refinanced my car, I refinanced my school loans, I went from a PhD student making $80,000 a year while pregnant to making $20,000 a year, because that's how it affects you. And I will go on about the mediation.
Can I ask you a quick?
Sure.
Okay, so the way, what I take from your testimony, it is that you feel like you were kind of forced into this mediated settlement?
Yeah.
Who forced you into it? Was it your lawyer or the mediator or your spouse?
A combination of all of them. When you're, I was not fully explained the laws. Like it said, you know, I had previous rights and duties. Well, I didn't understand that I had already had by the judge taken away my rights and duties. It also said, well, these are my, and then I have these rights. And I said to my attorney, well, what are these rights? And he said, read them, but he didn't inform me of all these other rights that I didn't find out about until I went and read the Texas Family Code book and checked it out of the library and spent a couple weeks reading it. And I was shocked to learn in many, many ways that the mediated settlement agreement violated the laws in terms of Texas Civil Code and Texas Family Code.
So what would be the alternative? What's your suggestion for a fix for that?
I wrote down my suggestions in the end. I did go and try to go to the courts, and this is one of the problems that you would need to address is when someone goes back and says, wow, like I signed this, the way it's either been enacted or because it puts me on professional supervision almost permanently. If someone says I said the wrong thing to my child or I shut a door and it slammed, well, I've misbehaved and now my supervision extends and it's past the financial ability, past my financial means. And a judge needs to have the oversight and authority to look at something and say, does this separate a good person from a child?
Okay, so did you go back? You did go back to
for 6 months. And during that 6 months, I not only was thrown in jail for 30 days, I also,
what were you thrown in jail
for contempt of court and failure to pay $36,000 of attorney's fees that were awarded as enforceable as child support, and they never should have been awarded in the first place, and I did not have the ability to pay. I gave an affirmative defense and said that I did not have the financial ability to pay this. I also was prevented from bringing evidence about this, but a judge still did not take that defense and, you know, basically enforce the mediated settlement agreement to such an extreme extent, it's made me lose all contact with my child for 7 months and face jail.
How can we fix that?
A judge needs, what I'm seeing when I go to court is a judge says, well, you signed it. You agreed to pay these fees. You agreed to supervision. All my role is to enforce what's here on the paper. When you can read what's on the paper and it's absolutely contrary to what it should be. So a judge needs to have that ability.
Well, I think the judge has the ability now to set it aside.
Well, they're not. I filed.
I don't know how we pass a law that says you have to.
Currently the mediated settlements agreements say that they're binding and irrevocable. I filed 4 days after they filed a motion to enter the final order based on the mediated settlement agreement. They filed within a few days I filed a motion to revoke it and to have it thrown out. And a judge at that time should have looked at it and said that, and that's not what they're doing. I'm prohibited from bringing evidence of recordings during the mediated settlement agreement because the way the law is written now, I can't promote that. So I can't say, actually, I recorded it. I was under extreme duress. I was threatened with my life, my liberty, and, you know, any contact with my child. So you need to have more oversight. It should be a requirement that things are recorded. And a judge, even if someone doesn't go to court or if someone goes to the DRO office, which you, by the way, can go to without being destitute to get enforcement, a judge needs to be able to look at something and say, like this doesn't make sense. You know, mother's not seeing her child. Well, what has she done wrong? Why is she on supervision? You know, or
I think a judge can do that.
Well, they're not.
Well,
so, and I've been cited that it's the way that the mediated settlement agreement is, that I basically essentially agreed to that. And that goes to the kind of the pro se litigant issues where you can't have that. I put down some other suggestion. Oh, here's what I came up with. I get nervous in front of speaking. I'm a biochemist by trade, not a public speaker, but the committee needs to require that all agreements follow the bounds of Texas Civil, Criminal, and Family Code. And like I said before, require the submission of evidence after the fact. I discovered evidence for 4 months that the father doesn't care for my child. The court didn't let me provide that and say, will you sign this agreement? So there needs to be some safeguards in place where if something else comes up or if someone else wants to present evidence, that they're allowed to do so. And having someone, it sounds like you don't want to hear my whole speech, but I don't.
Well, no, I mean, what we're focused on
Yeah.
is what the problems are and where the solutions are.
I think attorneys can tell people, here, you need to agree to this order. In my case, almost every single order, with except for, I think, 2, were agreements. At the beginning of the litigation, for the first 2 years of litigation, I should have never signed from day one an agreed order for a guardian ad litem. I thought, well, I didn't even know the term in my mind because of my, prospective training, that means I agreed to it. I didn't have to agree to a psychological exam. These things people should not, they're not given the correct information, and maybe the committee needs to compile something where everyone, it's mandatory, that says, you don't have to agree to this,
Well, I think we've always operated from the assumption that in family litigation, like any litigation, the best way to resolve it is through an agreement, through a settlement. That's an ideal situation, but, the issue you raise is what happens when, a party agrees to something and then later on finds out it wasn't what they necessarily thought they were agreeing to.
Exactly.
And,
it's a hard problem to
that's
solve,
it is
and
a
I'm
hard
sure
problem,
your
yeah.
creative minds, you must come up with something. I mean, I have an empty nursery up in upstairs in my bedroom home, and I don't see my child at all.
All we can do is tell you that we'll look at it, and take it seriously,
Thank you. I think having something where
Of course,
you
a lot
don't
of
have the
this-
same arbitrators, pardon me.
I would talked over you, I didn't mean to, I'm sorry.
Oh, no, you go ahead.
Well, I was gonna say, a lot of this is outside of our jurisdiction,
Right.
because there's a committee
Mhm.
that does juvenile and family issues.
Yes.
And so we try to, kind of recognize that line of division there.
Well, I
But
think in terms
some
of the
it's-
law, when you have the same arbitrator on cases over and over and over, that can breed corruption, right? There should be a limit. Someone should just be able to arbitrate a few times, because all these people are friends and they're going back and forth, and they're like, well, you convince this client on this one and I'll convince my other client on this one. We both make $400,000. I've paid $400,000 into my system for what?
Well, and you've raised a good issue here, and it's not just in family law, and it's, as we try to encourage people to enter into settlement agreements and hopefully settle some of these cases without lawyer involvement or even judge involvement, you're gonna get some people sign settlement agreements that they probably shouldn't sign.
Yeah.
And probably don't wanna sign, and, I think that's a good thing, a good point that we need to be mindful of.
Well, laws are in place for a reason. There's a reason why there's a law in place saying there's a limitation on how many attorney's fees can be awarded for certain cases. There should be limits on that. Or attorney's fees can't be awarded for establishment of child support. That's what was awarded in my settlement agreement for $36,000. And then when I ask the courts, they award the other party another $15,000 against me. But I think, yes, you do need to have some way where it's more, the system is transparent. Transparency is an absolute must, and I think if anyone talks about to their attorney, you should have a law. Like, I told my attorney, I said, here's a story. I cannot talk about it. I wrote it down on a page for you, and it tells you a story of horrible abuse. And in that sort of case, or if someone tells their attorney something, the attorney needs to be made illegal where they go to something else, a more transparent mediated settlement agreement, or a more transparent mediation situation where it can be revocable, because people can get in certain states, their psychological effects and the effects of trauma on a person. Nothing's greater than going through trauma, the way the brain changes. The prefrontal cortex does not make good decisions, the limbic system gets overactivated, and people will almost sign anything. I hadn't seen my child for 2 months. They said, sign this, you'll see him in 3 days. I'm about to cut off my hair, and you want a hand too, that's fine. So I think having some safeguards for following the law and greater absolute transparency in these situations would be really helpful for all of us. And a mediation at the very beginning, before years of litigation.
Okay. Any questions? Well, we do appreciate you being here. Hopefully, we can bear that in mind.